الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين. وبعد, after praising Allah Tabarak wa Ta'ala, ثم الصلاة والسلام على رسول الكريم, and sending salutations and salam upon the noble messenger Muhammad sallallahu alayhi wa sallam. We resume these academic series on Fiqh and النوازل, studying contemporary issues that the scholars have presented in their majami' al-fiqhiyya, the resolutions that they have concluded with of fatwa and verdicts. So before we move on regarding today's topic and today's discussion, I wanted to point out that with these nawazil, the stronger a person is in fahm and understanding and comprehension, the greater he will be granted in success in deriving a correct ruling regarding it. Yes, al-ilm laysa bis-sin. As the scholars have mentioned, knowledge is not restricted to an age, and that a person could be granted a lot of knowledge even at a young age, but in terms of fahm, understanding, it is greatly found with the elderly age, as hifz is greatly found at the youngerness of the age of a person. So the stronger a person hifz, the memorization that he has of what he could recall and memorize, it is at a younger age. And the stronger he is in his fahm and his diraya and understanding, it usually comes with an elderly age. And the proof for this is the hadith in Bukhari, where Urwa ibn Zubayr said, قُلْتُ لِعَائِشَةَ وَأَنَا يَوْمَئِذٍ حَدِيثُ السِّنِّ. He said, I said to Aisha, and on that time I was young in age. And he's specifying this for a reason. أَرَأَيْتِ قَوْلَ اللَّهِ عَزَّ وَجَلَّ إن الصفا والمروة من شعائر الله فمن حج البيت واعتمر فلا جناح عليه أن يطوف بهما. The ayah. So he mentioned regarding his understanding about that verse in Surah Al-Baqarah, verse 158, where he says, فما أرى على أحد شيئا أن لا يطوف بهما. He said, I don't see that there's any sin or blame upon anyone to do tawaf upon them. So Aisha says, كلا لو كانت كما تقول كانت فلا جناح عليه أن لا يطوف بهما. If he said the affair was like as you mentioned, it would have been worded differently. So Shaykh Abdul Muhsin Abbad, taken from this and derived from this hadith, that understanding perhaps may lack at a younger age than how it would be at an elderly age. And yes, this is not always the case. People may vary. It's not an absolute qaida. But with this, that the topics of nawazil, the more elderly and senior a person is in experience and also in fahm, the greater it is in also deriving and taking rulings. And this doesn't mean that scholarly that are young in age, they cannot share the inputs. Because we found that Shaykh Islam Ibn Taymiyyah, he was perhaps not the eldest of the scholars of his time, and yet he was the most knowledgeable of them. And he was a returning point. And he was considered to be someone that was at youngness of age, yet he had an understanding that was greater than some of the senior scholars of that time. But this is just to show in terms of majority case scenario. It comes on Abdullah ibn Mas'ud, the Prophet ﷺ described the Khawarij by saying, يخرج في آخر الزمان قوم أحداث الأسنان سفهاء الأحلام. Yani that is going to come, emerge after the ending of time, people that are young in age, foolish in their mindset. يقرؤون القرآن لا يجاوز تراقيهم. They read the Quran, it won't go beyond the throats. يقولون من قول خير البرية, and they say words of the best of speech. And then it mentions يمرقون من الدين كما يمرق السهم الرمية. They leave the religion as an arrow leaves the game or the animal that has been hunted. طيب. So when we look at this, it shows you that with the seniority of a scholar, the more years that he has of understanding, the greater it is in returning about these affairs of, and that's why the majlis of Umar ibn Khattab, it had the elites of the Sahabas for these nawazil and bringing their experience and their understanding to derive and understand the rulings. And we know that the scholars, they vary in levels. And also the people who speak, they are not just anyone that's given this title. The Prophet ﷺ said in a hadith Abi Dharr, إنكم اليوم في زمان كثير علماؤه قليل خطباؤه. Verily you're today in a time where it has many scholars, however few speakers. And this hadith is authenticated by Sheikh Albani and also comes from the statement of Abdullah ibn Mas'ud, verily you're in a time which the scholars are many and the speakers are few. And verily there will come a time after in which the speakers will be many and the scholars will be few. And some of the wordings, fuqaha instead of ulama, jurist. So when it comes to maybe someone that can give a sermon or lecture, there'll probably be so many different speakers. But when it comes to nawazil and really deriving the matters as they deserve and understanding them thoroughly, perhaps there's few of those people. And this time perhaps, and also in comparison to what has preceded. And we see this, that the timing of the scholars of real knowledge and firmness and strongness of that, rasikhin fil ilm, those who are groundly firm, they're getting fewer and fewer by the passing of time. They're getting fewer and fewer by the passing of time. طيب. So does this negate, and the reason why I keep doing these disclaimers, just so we understand that these are general statements of majority case scenario, that the nawazil are usually for scholars of seniority that have many years in experience and also in knowledge to derive and understand. And it could be that even someone young could be involved in taking his ra'i, his opinion. And the proof for that is how the Umar ibn Khattab brought Ibn Abbas into that majlis at times, alongside the elites of the Sahabas, to hear his opinion. And he's really young at that time. So it shows you it's not only for the major or senior scholars in age, but it could be for even others, but that's the origin. scholars that have a number of years on their shoulders, that have been able to derive the rulings with their understanding that Allah subhanahu wa ta'ala has granted them. And it warns us from people that are young in age and haven't yet become strong in matters of understanding of the religion to speak about these affairs of nawazil. And we're going to give example. This particular topic that we're going to study today, discussion number 5 from the topics of modern day nawazil, al-Ijar al-Muntahi بالتمليك, rent-to-own contracts. The verdict that we're going to read first is Hay'at Kibar al-Ulama, the Council of Senior Scholars in the Kingdom of Saudi Arabia. This particular verdict that we're going to read, it consisted about 19 scholars that came together. I think 19 or a little bit more. They said it was supposed to be more. I think 2 was absent. One was ill, or one of them was ill, another was absent. And also I once speaking to Sheikh Ahmed Al-Mubaraki, who was from the members of Lajnat al-Da'ima previously. And he mentioned that he had a meeting with Hayat Kibar al-Ulama, 22 of them for just one particular verdict. So that's how they do it. And usually it's not a majority vote case scenario. How do they come to the conclusion, brothers? A person may ask for these nawazil. They look to afdaluhum, those who are the greatest of them in ranks and virtue, and they see what they have to say, and then they consult the rest, and they look to hear and see if there's maybe an opinion that's singling out, and it doesn't have, like they say, like a shadh, مخالفة لمن هو أولى من. عرفته. What does that mean, brothers? In mustalah? Who knows? Who's the brothers that study the Majid? تفضل. الشاذ, the irregular. An opinion that's irregular, or a narrator that's irregular, or hadith. It opposes sifatan or adadan. It opposes in description. Like there's greater scholars in understanding, in rank, in virtue. And then also in terms of numbers, he's outnumbered. Here, usually that opinion, when it opposes, it's not really held and accepted. In terms of this is how they come to their resolutions. So now the brothers see how they come to their conclusions is from this angle that it has an origin to science of hadith. Science of hadith. And yes, at times a person could oppose those who are higher in rank and more in number than him. And if he has a justifiable reason, his opinion could override all of them, especially if it's supported with so much evidence. But this is how the origin, how they process their verdicts. Especially with nawazil, they said it's not ijtihad al-afrad. It doesn't require ijtihad of individuals. It is looked at from a collective point of view of a number of scholars. So with no further delay, we'll ask the brothers to read. Inshallah, that was just a muqaddimah. That was an introduction, brothers. We hope the brothers understood that. تفضل.
بسم الله والحمد لله والصلاة والسلام على رسول الله. أما بعد, what are rent-to-own agreements? Rent-to-own agreements, sometimes called a lease-to-own agreement, include a standard rent agreement and also an option to buy the property at a later time. In a rent-to-own agreement, the lease usually pays a higher monthly rent than they would for a traditional rental property. A rent-to-own agreements have different forms and methods.
طيب. So what we have before us is الإيجار المنتهي بالتمليك. الإيجار, a rent agreement, that is المنتهي بالتمليك. It ends with ownership. Rent to own, in other words. Lease to own. They have different wordings. They call it lease to purchase. All of this is what is included in today's topic. But before that, we want to speak about the topic of rent. There's a traditional type of lease, or a simple lease, they call it. And before that, a basic form of rental agreement. I'll give you an example of a basic rental agreement of renting a car out. A person needs a car for a day or two. That is a basic rental agreement. That is not like the lease. So a person wants something for a long-term period that he's renting. That is referred to the lease. The version of a lease is a simple process of renting, for example, a vehicle or a home for a specified time period. Most of the time, these types of lease are for, in terms of vehicles, new model vehicles, and also for homes and new real estate or new houses, whereby the leasee is renting upon certain restrictions in mileage and usage, and once the lease term expires, the leasee must return the vehicle to the dealership. After this, he may choose to extend the lease or upgrade to leasing a higher model vehicle. The forms that are usually signed for this type of lease varies from one dealership to another. Therefore, the ruling for this type of lease depends on the content of its forms and its terms. So the traditional lease, or they call it the simple lease, like what is the ruling of leasing a car out? Leasing a car out. That's where the question usually comes forward. Scholars of the Fiqh Council and the Permanent Committee, they listed a number of conditions that has to be considered for leasing. Before we speak about lease to own, we need to speak about leasing in itself. When you're renting, the meaning of rent should be applicable in your contract. I mean, sometimes they're saying you're renting, but you're actually treated as a buyer, like who owns the car, maybe in terms of losses. But in terms of profit, you're treated as a leasee, someone renting. It's always a disadvantaged type of relationship. And when it comes to, we tell them, okay, when it comes to insurance, if I'm renting, you're the one that should be paying the ta'meen, the insurance. He says, no, you have to pay the insurance. Okay, so if I'm paying the insurance, if I get into a car crash and the money's in my advantage, who's getting the money? He says, I'm going to get the money because I'm the owner of the car. I says, subhanAllah, this type of relationship is found in a lot of lease. It's somewhat unbalanced in terms of where it is at times you're treated as an owner and at times you're treated as someone who is leasing, the leasee. So let me point out some of the conditions that the Fiqh Council of Jeddah and the Permanent Committee of Iftah gave for a lease of a car to be permissible. They said, number one, if during the term of the lease and until the return of the vehicle is damaged or destroyed or stolen or abandoned or taken by any judicial or governmental authority. Pay attention to these wordings, brothers, because this is what they put on their contracts. The leasee should only be financially responsible if he was a cause by either negligence or willful misconduct. That is the time. But if you look at a lot of the lease, vehicle lease, they have that, and I'll read you, specifically let's read Honda's, inshallah. So the brothers could see, and they said, بِالْمِثَالِ يَتَّضِحُ الْمَقَالِ. With striking example, speech becomes clear. I'll read another one here. This is a lease agreement for a car in America. So they say damage, destruction, or loss of vehicle. If during the term of this lease and until the return of the vehicle it is damaged, destroyed, stolen, abandoned, or taken by any judicial or government authority, the leasee will remain financially responsible. Does that go against that condition that we mentioned, the fatwa? Yes, it goes that kind of condition. But not all of the leasee auto companies put that. Some of them put with negligence or something on their part. They give exceptions. So you look at that. And I'll read further, inshallah, other examples of Honda and that, so we can see. The next condition that they give for lease, there should be no late fees or penalties except for overuse, exceeding the due date for returning the vehicle, or due to terminating lease with no justified reason before its term. So there should be no late fees or penalties except for overuse. So they give you like a mileage restriction. So if you go over the mileage, you have to pay a particular percentage for every mileage rate that you go over. Or if you go beyond the limitation they give, they say that if you can only drive this car in North America, for example, or somewhere. If a person takes it on, there's a penalty. These type of penalties, it's allowed, the scholars called it Shartu al-Jazai. What does it mean of Shartu al-Jazai? You can put a penalty for other than duyun, for other than money that is owed. So if you say to a person, if you do this and this with the car, there's a penalty when renting, or you're renting a house out. And you tell the person, if you use this window, there's a penalty. And you agree to that, then there's a penalty. So Shartul Jazai, it is acceptable as a term or an agreement in the contract. And also, when terminating the lease, and most lease, auto lease, and even home lease, there's a huge penalty, cancellation fee. And some of them say without any justifiable reason, and some of them just leave it outright. That if you cancel before the ending of its term, it's considered a default. And if it's considered default, your down payment that you put is taken. Everything that you put as money is no longer refundable. So this one is a little bit of question, but in reality, if a person agrees to this, agrees that if he exits within the term, then he pays the cancellation fee, then it is somewhat accepted. طيب, the next, and as for the no late fees, with late fees, we spoke about it previously on finance. That is something that the people are being trialed with, especially in everything now that is being presented, there's late fees. Late fees, it is a huge trial, especially in the conventional market of the West. It's really hard to avoid something that doesn't have late fees. You're going to be really deprived of essential services or things that you will be in a state of somewhat of haja, that you'll be deprived of needs of your worldly life because of trying to avoid it. So in scenarios where a person is trialed, then the sin is upon those who have trialed the people with it. And it's upon you to strive to pay in a time. And you can establish a good record with these companies that if you're known to always strive and also explain for religious reasons that you're trying to avoid, they will do what they call a waiver. So they waive off any interest for you, especially if you have a good record. If you happen to go beyond the due date, they would wipe it off for you because of your good history. So try to establish that relationship, inshallah. The next condition that they usually give, and this is taken from a book called Shari'ah Standards. It is somewhat approved, some of the verdicts by Sheikh Sa'd Al-Usaymi and others. It's found in English. معايير الشرعية is in Arabic. A good PDF if you want to know about any business type of financial transactions. They have nice answers and conditions for every type of transactions out there. That the insurance should be by the leaseor. And the leasee should not be financially responsible for the expenses of the insurance, except if it's included as a fixed amount in the contract of the lease. That's what exception they give in the verdict. Like if it's included as a whole amount. You're paying monthly and your insurance is included in that. Like now car rentals. You do a car rental subscription for a monthly subscription or something. You have maybe the whole insurance is a package. So that is what they're saying is allowed. And nowadays, it's completely impossible to lease a car while they are paying for the insurance. Somewhat impossible. It's like ma'doom or shibhu ma'doom. Probably non-existent. If there's a situation where it's an agreement that implies take it or leave it type of agreement, then some of them say that this type of condition, even though it's fasid, it doesn't nullify the whole contract in itself. And this is a ikhtilaf between the fuqaha. Does one corrupted, invalid condition in a contract nullify the whole contract? So some of them said that this contract is still valid. You can still lease the car, but this is an issue, and we'll speak about it in depth, inshallah, but we want to point this out. Because now if you even go to the Honda or different companies, let's read here's a Honda leasing contract that I want to read. They said at all times during the term of this lease, you must at your expense obtain and maintain the following minimum insurance coverage. And they give the amounts. Public liability for bodily injury, collision insurance, comprehensive fire and theft insurance. And then also with that, you have to put them as an additional insured, that company that you're leasing from. And a loss payee, and they can take, and even they put other conditions that they say to receive or collect any money paid under the insurance or you assign to us any monies paid under the insurance by whomever obtained, and you authorize us. So it shows you, brothers, this is a relationship that has them always up an upper hand. At times, whenever you object, they just say to you, you are the leasee, we're the owner. And other times you're told to do something and you're treated as the owner, not the leasee. So this is what is questionable about leasing cars, brothers. Leasing cars, They say it doesn't really meet. What about what they call the interest rate? Sometimes when you lease in a car, they call it that there's an interest rate. They just give that a name, but it's really called the money factor. The money factor is profit on the assets, profit on the car. So they're making money, an additional money, and the way they may probably calculate it at times is how an APR is calculated. So that's why they may give that a name. Or how banks and different companies, financial institutions, how they usually determine it. They will determine it as like a loan. They'll treat it as like a loan, and they'll give it the same title. But in reality, it is not interest. When leasing a car, when they call it financial charges on your contract. That extra money is profit. It's a markup of what they're earning extra. And that's one of the benefits of leasing. They could charge you so much extra for the long term of the agreement. So now we're going to go, inshallah, now that we know generally about leasing car, and we'll speak what is its ruling at the end, and probably we want to go back to our topic, leasing to own. What is leasing to own? Because there's a various of different forms. They said there's over 10 different forms of the contract, leasing to own. For that reason, when it initially came out, many scholars maybe probably just gave a verdict on one surah, بحدداتها, just one form. And then later on, as it evolved and had different forms and different ways of leasing to own, they may have given exceptions. This is how it all evolved. Inshallah, we read, inshallah. Tafadhal, brother.
What are the different rulings that scholars have issued? Concerning its Islamic ruling, some contemporary jurists and modern-day fiqh councils have issued verdicts regarding it. Number 1, the Council of Senior Scholars in the Kingdom of Saudi Arabia, هيئة كبار العلماء السعودية. The Council of Major Scholars studied the subject of renting to own as its 49th, 50th, and 51st seminars. Based on multiple requests of a legal opinion received by the General Presidency for the Departments of Knowledge-Based Research and Islamic Verdicts, it studied a number of prepared research papers on the subject by several researchers. As at its second session held in Riyadh, the 29th day, October 1420 after Hijri, they resumed the study of the subject, and after research and discussion, the board in majority felt that this contract is not legally permissible for the following reasons. Firstly, it compromises of two transactions, that is rent and sale, on one commodity without abiding to either of the two transactions.
So they say, رأي المجلس بالأكثرية, يعني that the majority of that gathering, when all of them came together, I think 17 of them said it's not permissible. And or 2 of them said that it was permissible, and then others were absent. Told them.
It compromises of two transactions, that is rent and sale, on one commodity without abiding to either of the two transactions, and they are different in their rulings, incompatible in them. For the sale of a commodity or property obligates the transfer of the commodity and its use to the buyer, and at that point to again rent the commodity is not valid, since it is owned by the buyer. Also,
and this is what it comes in hadith in Musnad Imam Ahmad. نهى النبي صلى الله عليه وسلم عن بيعتين في بيعة. He prohibited 2 transactions that are separate in one transaction. So this is where they use of explaining this. They said here, renting is a separate transaction. When renting, you're buying the benefits of that commodity, not the actual commodity. You're buying the manfa'a. But with bay', you're buying the actual commodity, and entails transfer of that commodity of ownership. So it's different. They said they have different, like they can't come together. They're incompatible. So this is the first reason. Tafadhal.
Also, renting obligates the transfer of solely the use of the commodity to the one renting. Additionally, the item being sold is under the guarantee of the buyer, the commodity along with its use. Therefore, if it is damaged, then the damage to commodity or its use are upon him, that is the buyer. Neither of the two return to the seller.
And that's why when someone is buying a car, if he buys a car and suddenly like a natural cause were to happen, what they refer to as natural cause, like earthquake or tornado, we say there's no one liable except yourself. But if he is renting, in that scenario, he is not held financially responsible. He's not liable because he's not the owner. The owner is liable for these natural disasters, anything that was not out of willful misconduct or negligence on his part. And his car suddenly got stolen. He did all his part. He did security, everything. He tried his best to protect the car and it got stolen. Here, who's liable? They're saying, if they're saying that the person is treated as the buyer, at the same time renting, and this is going to cause a confusion between the two. And they're not compatible here. This is what they're saying. Go ahead.
And the warranty of the commodity being rented is upon the owner. Therefore, if it is damaged, then the damage to the commodity or its use are upon him, except if there occurs violation or negligence on the part of the renter. Secondly, the wage is determined annually or monthly in simplified amounts in order to attain the value of the commodity. This is considered by the seller to be rent, so that he proceeds in confidence with regards to his property, since it is not possible for the one buying to sell it while bound by this contract. An example of that, if the value of the commodity that was sold is 50,000 riyals and its monthly rent is 1,000 riyals under normal circumstances, the rent will be made to 2,000. And this, that is the extra 1,000 in fact, is a portion of the price of the commodity until its estimated value is reached. Then if the financial straits occur, with the final installment, for example, the commodity is repossessed, considering it was being rented, and whatever he had paid will not be returned to him because he obtained benefit from the commodity. It is obvious that this is injustice and compels the buyer into debt to fill the last installment.
So you find that the conditions that they put, the installment should be of an average rental price for the use of the car. No extra should be given to attain the option of ownership or the option to purchase or to buy at the end, since it is based on the condition of completing all payments, whereby if payments are not met, all the extra additional money that you put would be considered as rent and not returned back to the client. And that would be a form of injustice and speculation and therefore impermissible. This is what you're saying. And this is one incident, even this happens with renting out commercial places or buildings. There was an Islamic school, and the brothers are familiar with it. The person was paying rent and also a down payment alongside the rent of an extra amount that was going down for purchase, for ownership. So later on, I believe, if the brothers can correct me, the building of the landlord sold the property, and because we found a way out to sell it. So what happens? All of that payments that you were done was considered as rent, and nothing's returned back to you, even the extra money you put down as payment. So this is what they're saying. These two are not compatible. If you try to put them together, there's going to be oppression. This is what they're referring to. And even that same person was trying to take that landlord to court and to reclaim, and they had nothing they can do in that case. Hold on.
Thirdly, this contract and its likes has contributed to the indulging of the poor in borrowing money until many of them have become preoccupied with debt and debilitated. Also, it may lead to the bankruptcy of some of the creditors due to the loss of their wealth through the poor who have borrowed from them. and the council sees that the two parties carrying out the contract proceed in the correct manner, that is to sell an item and then return it is as security to the seller until its value is finally paid. And he, the seller, takes precaution by retaining the record of the transaction and registration form of the vehicle and so on. With Allah, His success and peace and salutations upon the Prophet Muhammad sallallahu alaihi wasallam and his family. End of quote.
So they brought forward, like, what about if the person fears for his vehicle and you're giving your car to rent to someone? And shouldn't you put your car as with this condition? And when the company is leasing, they want to secure their property. So here they said to make it as a rahan, a collateral. You're allowed to do that. You say that this vehicle is collateral. If you don't come and meet all payments, we're going to use this vehicle that we're renting to you as collateral that we seize to secure anything that is due, to make up certain payments. And this is what they're saying. They should make it an actual sales and use the car as a collateral instead of using this process of rent. Because if you ask them, why are they doing this renting process? They say, we want to assure that this person is going to actually pay installments. If we give him ownership like that, khalas, and he doesn't pay the full amount, what happens? He walks away, he has ownership of the car, and he still owes us money. So they said, let's make this method, we make him pay in installments as a leasing. And if he meets most of it, at the end, we give him a particular lump sum, and we say, here, pay the rest, and you own the car. You own the car. Or we give him a gift that he has included package that he owns the car after completing the terms. So a lot of the times they're doing that for that reason, to secure the payments under the name rent. So this is the scheme that they're talking about, and this is why they see is not to be permissible. And those who signed this particular verdict was the Mufti Abdul Aziz Al-Sheikh, Sheikh Salih Al-Uhaydan, Sheikh Sa'd Al-Fawzān, and Sheikh Muhammad bin Sa'd Al-Usaymi, and Sheikh Bakr Abu Zayd. So they are the ones, and others signed alongside them, but these are the main scholars. There was other scholars that deemed it to be impermissible. And I'll read you here a further verdict of Sheikh Muhammad Salih Al-Uthaymin about this transaction. He says, I see this transaction to be impermissible because it consists of combining two contracts in one, buying and renting at the same time. Because he says, is he an owner or is he renting? In reality, he says he's not an owner or he's a renter. Because you find him just all over the place during the contract. If the car is damaged, who is liable? Is it the leasing company, or I would say the renting company, or is it the person renting it out? Who is liable? If they place it on the person renting, he says, هذا لا يستقيم. And he says, إذا كان عنده آخر قسط وعجز عن دفعه ماذا يكون؟ تؤخذ السيارة والدراهم التي أخذت أولا وهذا ظلم. If he can't pay the final maybe installment, and he's incapable, he can't meet the due dates, the car is taken from him and all of the money that he paid previously. And he said this would be oppression. And some people, they come in, they say that I'm going to pay all the amounts so I can get ownership at the end, just to avoid this type of situation. So the Sheikh says it's not guaranteed for you. You can fall ill, anything could happen and not be able to pay at the end. So he says there's this type of speculation there is some sort of risk factor. So that's Sheikh Muhammad Sa'd Al-Usaymi. Also, there's a verdict with Sheikh Ibn Baz where he's against it. But they were mainly referring to one main type of rent-to-own contract. When it first came out, it was somewhat confusing because they would have all the terms and everything into one agreement. So inshallah we're going to read further and then we're going to comment inshallah. Tafadhal.
Number 2, the International Islamic Fiqh Academy, Al-Majma' Al-Fiqhi Al-Dawli, they published the following statement. The Council of the International Islamic Fiqh Academy of the Organization of the Islamic Conference, holding its 12th session in Riyadh, Kingdom of Saudi Arabia, on the 25th of Jamad al-Akhirah to the 1st of Rajab, 1421 after Hijri, the 23rd to the 28th of September in the year 2000, having examined the research papers submitted to the Academy concerning renting ending in ownership and leasing bonds, having listened to the discussions of the Academy's members and experts and other scholars, the resolves. Number 1, renting ending in ownership first. The criteria for the permissible and prohibitive forms are as follows.
So first they had a gathering, the International Islamic Fiqh Academy, and they first gathered and then they postponed. They said this needs further research. Then this is their second gathering where they concluded with something.
The criteria for the permissible and prohibitive forms are as follows. A. Prohibition criteria. When the transaction involves conclusion of two different contracts at the same time for the same commodity and for the same duration. B. Permissibility criteria. Number 1, the presence of two completely separate and independent contracts as to the time of their conclusion and in which the sale contract succeeds the lease contract, or the presence of a promise allowing the leasee to become the owner at the end of the contractual period. The option and the promise are on equal footing with regard to the Shari'ah rulings. Number 2.
So they're basically saying if there's a rent-to-own agreement, that tells you it's like two separate contracts. It will say on the lease that you have option to purchase. And then once you're done, when you're doing the purchase, they'll give you another final agreement. So it's like two separate. And also, when you're doing the renting, it doesn't entail any extra payment. Everything is renting. It applies to you all the rulings, and then at the end of it, you have the option to purchase. So that's the one they see permissible. Go ahead.
Number 2, the existence of a genuine desire from both parties to conclude the lease contract and not just to use it as a mere veil for the sale contract. Number 3, the leased property should be guaranteed by the owner and not the leasee.
Yeah, so what we mentioned, the reason why a lot of the times they're providing this type of lease instead of just selling you the car in installments is they're using this for their advantage. So it's a disguise, it's really for you to purchase the car. Go ahead.
The leased property should be guaranteed by the owner and not the leasee. In this sense, the owner should bear any damage that is not caused by the leasee's misuse or negligence. The leasee has nothing to bear, even if such damage has rendered the property completely useless. Number 4, if the contract includes property insurance, the cooperative insurance should be non-commercial, Shari'ah compliant, and the sole liability of the owner.
And alhamdulillah, I think in some countries they're introducing this cooperative insurance called Ta'min al-Ta'awuni. There's one company, Islamic institution called Falah. They're slowly trying to bring in a premium that is an Islamic type of car insurance. So slowly and surely, inshallah, is going to be introduced Some countries have this more, but as of now, we only have the commercial insurance, and we're forced to do that. To drive a car now, you need the commercial insurance. But once the cooperative insurance takes a toll and takes control, we should move to that one. And say to the people, I'm only going to lease the car if you allow me to take that insurance. I don't know, it's full of them. And that insurance is, it's like a circle of wealth that is just, it's not built upon profit, it's just cooperative and helping one another. So if you don't use the money, you're still somewhat entitled to it. It's like that money is yours. Go ahead.
Number 4, if the contract includes property insurance, the cooperative insurance should be non-commercial, Shari'ah compliant, the sole liability of the owner. Number 5, during the entire lease period, the contract should be subjected to Shari'ah rulings regarding ijara, whereas Shari'ah rulings on ownership should be observed when the property ownership is transferred to the leasee. Number 6, the cost of maintenance, excluding operational expenses, should be borne by the leaser and not by the leasee during the entire lease period.
So there's general maintenance and there's operational maintenance. So operational maintenance, you have to change the tire of the car, you have to put an oil change. That type of thing is your duty renting the car. And there's things that are outside of operational maintenance. It relates to the owner. He said, this is not mine, I'm just renting. These things have to do with you. And any norms and any customs, they will say this belongs to the owner to do these type of maintenance of the car. So yes, some lease companies, auto lease companies, they provide certain packages of maintenance and repairs. Even if the car is damaged, they include it. So if you can get that, alhamdulillah. But if they put it all on your shoulder, and everything, then this is where it's doubtful, they're saying. Follow?
Second, some prohibited forms. A renting ending in ownership contract that leads to the transfer of ownership to the leasee against the amounts of rent he pays during the contract period without signing a separate sale contract. In other words, it is when the same lease contract automatically changes into a sale contract. B, a lease contract according to which the property is given to the leasee against a specific amount of rent and for a specific duration, coupled with a sale contract that becomes effective only when the leasee pays the whole amount of rent agreed upon or at a specified date in the future. C, an appropriate lease contract including an option for the owner to sell the property to the leasee at the end of the leasing period. The above-mentioned legal opinions have been adopted in the resolutions and fatwas of various Islamic authorities, including the Council of Senior Scholars of Saudi Arabia.
طيب. So this is the verdict of the international, which is like second in line of the strongest committees, the fiqh councils out there. This is one of their verdicts about rent-to-own contract. These conditions, you should bear them in mind. We'll take another one. Move on, inshallah.
Third, some permissible forms. Number 1, a lease contract that allows the leasee to make use of the leased property against a specific amount of rent and for a specific period, along with a separate contract offering the property as a gift to the leasee. The latter contract takes effect at the end of the lease period and when the leasee has paid all the amounts of the rent agreed upon. A promise from the owner to give the property as a gift to the leasee after the lease period and full payment of due rent is also acceptable, as per the Academy Resolution number 13 on Hiba gifts at its 3rd session. B, a lease contract offering the option to the leasee to purchase the property after the lease period and the full payment of due rent at the then prevailing market price, as per the Academy Resolution number 44 at its 4th session.
And that's what a lot of lease companies, once you complete, they give you a number of options to upgrade your vehicle to another type of model that's higher. And even sometimes they give you the option to purchase, then they'll give you the option to trade it in. And like you have these options at the end. So this is what they're mentioning as permissible. Hold on.
Number 3, a lease contract that allows the leasee to use the leased property against a specific rent amount and for a specific period, coupled with a promise from the owner to sell the property to the leasee after the full payment of due rent at a price to be mutually agreed upon. D. A lease contract that allows the leasee to make use of the leased property for a specific amount of rent and a specific period, while the owner gives the option to the leasee to own the property at any time if he wishes so. The sale in this case is to be made according to a new contract in due time and at the then prevailing market price, as per Academy Resolution number 44, or at any other price to be agreed upon at the time of concluding the sale contract. Fourth, there are some other forms of renting ending in ownership that still remain controversial among some fuqaha. These forms require a thorough study to be presented to the Academy in one of its forthcoming sessions.
So some of them, up until now, they're mutawaqqifun fiha. They haven't released a verdict. And we don't know what their position is. They haven't released a verdict. Regarding renting to own, there's generally 6 opinions. They said the ulama have 6 opinions. And the first opinion is those who say it's not permissible, absolutely. Second opinion, those who say it's permissible upon that the owner gives the car or the house to the person after completing the rental agreement. Third opinion, that is permissible if the lease company gives you the option to purchase. And that's what we just read of this fiqh council. Number 4, that it's permissible if there are 2 separate contracts, 2 separate agreements. They both have 2 separate contracts that you have to sign. One for rent, the other one for purchase. Number 5, that it is not permissible from an angle of commitment. Like they make you sign a commitment agreement that you're going to purchase the car after. So Lajmat al-Daim Sheikh Baz, he says it's not permissible. And the last opinion, that it's not permissible if it automatically, by the ending of the rental agreement, it becomes a purchase. And this is the 6th opinion. And this is the Muslim World League. That's their verdict. برابطة العالم. So those are the opinions. There are some other opinions that we're going to read that we included in here, inshallah. تفضل.
Number 3, the Assembly of Muslim Jurists of America, AMJA, they stated the following: this transaction is a lease contract with a motivation to buy for a discounted price. There is no legitimate reason to prohibit such a transaction.
And that's their opinion. As we mentioned, a lot of the verdicts is not the best, so you have to reconsider it. Follow?
Number 4, the Accounting Audit Organization for Islamic Financial Institution, AAOIFI, they listed the following conditions to be permitted. In إيجار منتهي بالتمليك, the method of transferring the title in the leased asset to the leasee must be evidenced in a document in the leased asset to the leasee separate from the إيجار contract document using one of the following methods. A, by means of by means of a promise to sell for a token or other consideration, or by accelerating the payment of the remaining amount of rental, or by paying the market value of the leased property. B, a promise to give it as a gift for no consideration. C, a promise to give it as a gift contingent upon the payment of the remaining installments. In all these cases, the separate document evidencing a promise of gift, promise of a sale, or promise of a gift contingent on a particular event should be independent of the contract of إيجار, المنتهي بالتمليك, and cannot be taken as an integral part of the contract of إيجار.
طيب, ما شاء الله. What is the khulasa of this? What is the summary? Let's go back to the ruling on leasing a car. Leasing a car, firstly, from a financial advice, it's not advised. And in terms of the conventional point of view of it, it has a lot of clause that is not in your favor. Many people resort to it because they want to drive a particular model of a vehicle of a year and display a particular luxurious lifestyle of their own amount of wealth does not and they live to. So this is made easy for them, of that type of convenience. And it comes with a lot of expenses put onto the vehicle. So they have a capital amount that they're going to put as a price of the car, and then they put a money factor on it. What is the money factor? And sometimes the money factor comes as a decimal, small amount, 0.00, and sometimes it comes as a percentage. It's basically the profit that they're going to mark up the price of the initial capital. And they add also the amount of terms. They looked at the terms and they see the residual value, like how much is the car going to depreciate and how much is going to be after the end of the term. So usually, usually for the 36 months term, it's like 50%. So they look at it and they say, okay, we're going to put that in the calculation. So you end up paying within that. The monthly you're paying for the value of the car depreciating. You're paying for the price of the car of rental of what's monthly of that term. You're paying taxes. You're paying other fees. They put it all in and it comes to be a lot. So in terms of it being really expensive and not advised, that's what people usually say. It's better to work within your means. Find a used car and drive it, mashallah. Or find a car that you can afford and purchase it. That is better for you in terms of the long term. Yes, if it's rent to own, someone may have a reason to doing so. Because you're actually, at the end of the contract, you're just going to pay the difference of the value, the residual value, and of what you're going to compare what you've already paid and how much you depreciate. You're just going to pay that amount and you own the car. So people look at it as they're paying money they're putting money down to own the car, so they see it like in long-term ownership, and that's better for them. So this leads us to our discussion. So we're going to read some further fatwa, inshallah, individual fatwa of scholars regarding this. Sheikh Sa'd Fawzān, he was asked about this type of transaction. He says, this is not permissible because it consists of two transactions that are separate in rulings in one. And also it leads to ambiguity. You don't know what the outcome is going to be. Are you going to end by renting or are you going to end by purchasing? It's unclear your ending. They said, عاقبة الحال مجهولة. There's the gharar. The Prophet ﷺ prohibited speculation. That's his reason. Sheikh Abdullah bin Jibreen, from the previous members of Lajnat al-Da'imah, he gave a verdict that it was permissible. He said, even if they call it rent, it's really buying. This whole transaction, he says, it's not rent that ends with ownership. He said it is ownership. And he says they should they make the car as collateral, that they secure their wealth and their property. And if the person doesn't make the full payments, they take the car back as collateral. So he says this is not really renting, He says this is buying, this is a purchase. Even if they give it the name a lease or rent. He says because you're paying in installments for in reality ownership, that if you complete the term and the payments, you become the owner. And if you do not, they have the right to take your car because it was agreed on as being collateral. So they take it. And he brought some proofs for that. And he says, and in another verdict of his, لعل الأقرب أنه يجوز إذا كان قادرا على أن يسدد الأقساط حتى ينهي دفع القيمة ثم بعد ذلك يملك المنزل والسيارة ونحوها ويكون هذا العقد كمسألة الرهن الذي يتمكن المرتهن من بيعه إذا لم يسدد الراهن ذلك الدين والله أعلم. So he made in his latter verdicts before he died, he said what is closer is that it's permissible for someone that is capable of paying all the installments. And it wouldn't take the ruling of rent, it would take the ruling of someone paying installments as purchasing, and his car is just there as collateral. If he doesn't fulfill the payments, they take the car. Even that is still questionable, but that's his verdict. And the reason for all this differing, because the fuqaha of the past, they differed on certain topics. Like, for example, what is the ruling on placing conditions regarding a future date? Saying if on a future date you're going to purchase the car. Scholars, they differed on that, and a group of them said it's permissible. طيب, Sheikh Sa'd Al-Usaymi, a professor who studied this in depth, he says the prohibited forms of ijara al-muntahi بالتمليك is no longer in existence. He said it doesn't exist anymore. He said what is available now in the market is the permissible form, the option to purchase, the separate contracts. This is what he says. Unless each separate contract has its, there's other reasons for making haram, but the initial ruling of what was prohibited of rent-to-own contract, he says is no longer existent. That type of contract that the scholars prohibited. When does this contract first was brought into existence? Rent to own. Because when we say nazila, it's like a new transaction. They said the first time it was ever conducted was in 1846, the Gregorian year. And when it was really brought in, it was recognized as a transaction in the market in 1953, and it was brought to the Arab world in 1962. Or sorry, after that, some time. One of the reasons why a lot of the scholars have a problem with rent-to-own contracts, because they say a lot of the times you're paying more than the average rent of that car or house. You're paying extra. So they say that extra, it is being treated as rent, and it's not really rent. You're putting the extra as a down payment for the house. So they said you're putting down payment, and later on, if you don't fulfill the payments of all the term, that money is treated as rent. And they say that this is where they feel that the person has been wronged. Another thing too is making the person be held responsible for all of the damages without even any negligence from his part, and insurance. A lot of the scholars have it from this angle. They have a problem with it. And also they have a problem with the fact that once he finishes the rental agreement, it turns into a purchase agreement suddenly, from one contract to another. Sheikh Abdurrahman Al-Barrak, he says, يبدو أن هذا الذي يسمونه الإيجار المنتهي بالتمليك. He says, what is apparent, what people call الإيجار المنتهي بالتمليك, which the scholars have differed on. And he goes, I don't advise anyone to do this transaction لأنه عقد مزدوج. Transaction that has, it's a complex one, it has some confusion with it. لا هو بيع ولا تأجير. It's not buying, nor is it renting. بين is between, and you don't know what it is. ليس فيه ربا فيه جمع بين عقدين وهو التأجير والبيع. It's not riba, but it's consisting of bringing two separate transactions that are not compatible together. Okay, something to remember, whenever you're doing rent to own, they usually make you make a down payment. Usually make you make a down payment. What's the ruling on that? The scholars, they differed. And this deposit that you're putting, it's an urbun. The urbun, the Majma' al-Fiqhi, the group of scholars, they said يجوز بيع الأربون إذا قيدت فترة الانتظار بزمن محدود ويحتسب العربون جزءا من الثمن إذا تم الشراء. That down payment that you're putting in, you're allowed, so the person says if you fulfill the monthly installments, it's included part of the price. We deduct it as a price. If you don't, we take that money. And you get, it's non-refundable. And all most expenses, even on most lease, they say that all fees and all payments is non-refundable. So this is as well. If you agree to this, and then it's a correct transaction from that angle of the urbun. Bear with us, brothers, we're almost done. Allah is to the way. I hope we have some time for the next class. طيب. And sometimes you go to lease a car, they'll tell you 0 down payment. You don't have to pay any down payment up front. So it's incentives. There's incentives that they have. And even with some contracts of purchase to own, they give you a financing option. That right when you're done, there's a small lump sum left, they'll say, we even finance you and help to pay that car for you. Get you a loan. So this is what they want. Financial advisors online, they say, caution that rent to own is untested and has some pitfalls and risks. And you find that not all countries have adopted rent to own contracts completely, such as maintenance costs or the potential to lose the down payment in some instances if a renter fails to meet the terms of the deal, and he loses that money. So we know, let's summarize. To lease a car, it's whatever extra money they put in, even if they call it interest, it's not riba, brothers, because it's actually profit on the rent that you're doing. It's a money factor in reality. They're looking to get an increase of money. What about if from 1 year of the lease to the next year, there's a percentage where the money goes up? That's allowed in lease, as long as it's fixed and is known in the contract. Like for example, right now, even like a building like this, let's say every year the rent goes up 2%. This is permissible because it's known, it's fixed, and it's renting. It's not a debt, a loan. And you're allowed to do this. They're saying based upon the market value, things are going to go up, so you have to pay more every year. So even with leasing the car, if they were to do this, this is permissible. This is permissible. What about this contract that says if there's any damages, your car gets stolen while leasing the car, you're financially responsible. Or if the government comes and does something to your car, khalas, it's confiscated, you're financially responsible. That contract, it depends. If it has Ibn Jibreen mentioned in his Fatwa here, that this is really a purchase contract, even though they gave it the name lease and rent, this is permissible. You guys are with us? If Ibn Jibreen's Fatwa is correct, which I'm inclined to, brothers, that this whole title of lease is really a purchase. It's really a purchase. That's why you're trading in the car at the end. If you're not interested in the car at the end, you trade it in to get another car. Like you have now some value. That value that you obtained through those payments was like a purchase. You have some wealth now on your account. So this type of transaction is more like a purchase than it is a rent. So that's why it's allowed for them to put all damages solely on the leasee. Even though we have the title leasee, it is because it's different. Right now, if you rent a car and you get into a car accident, just rent a car from the airport. All damages is on the company, nothing on you. That is a real rent. But with lease, is more like a purchase. Mafhum? The brothers understand this? Because now we're trying to point out what the Shaykh was mentioning is actually somewhat that makes sense if you really look at the reality of things. And that's why the insurance is on your shoulders. The insurance is on your shoulders because it's more of you being the owner of the car, even though it's based upon so much conditions. While if you're renting a car from the airport, you can get it included with insurance. You can get it included with insurance, or they'll have their own company teamed up and they'll provide the insurance at times. So this is leading to us that it is leasing a car from what's apparent is permissible. Leasing a car from what's apparent is permissible. For these reasons, that is more like a purchase. You have like some sort of value that you obtained through that transaction that's in your account. For that reason, you have the capability to upgrade, the option to purchase with a small amount to make up the difference for all the time you paid, or to have the continuation to continue. All of this is, these options show you that it's more like a purchase, it's closer to purchase than it is to renting. And the ruling is takes to what is closer to. So, because we know it's bain a bain, we put it closer. And this ruling, bringing things to that which yushbihuha, is closer to, has an origin. And I'm not going to use the hadith, but it's, the person who killed 100 people, or 99, وَأَكْمَلَ بِهِ مِيَّةً, and he killed 100 at the end. Which path was he closer to, brothers, when the angel of death found him? To the good city. So they gave the ruling to what he was closer to. So sometimes, even in rulings, you may give the ruling to what a person is closer to, even when you're confusing. That's why even in the books of inheritance, when they're trying to decide if the person is, they don't recognize if it's a girl or a boy, they'll look to certain features that incline to which is more closer. So this has a ruling in fiqh, brothers. So what's apparent? That this transaction is closer to a purchase than it is to a rent. For that reason, most of these conditions that the scholars mention, it's not applicable because that's a more so for renting. And that's why here some of the mashayikh said that وَلَوْ جَعَلُوا بِاسْمِ أُجْرَةٍ. Because أرى أن هذا عقد بيع بأقساط مؤجلة. And let's read a few more things to conclude. One professor, he wrote a book and he went in depth. He did his masters, and some of them even went in depth. And his name is I believe Muhammad bin Sa'd Al-Usaymi. He brought this research and looked into it thoroughly, and then he said, after presenting the statements of the scholars, he says, يتضح رجحان جواز هذا العقد, that it's permissible, this transaction. وأن أصل في الجواز وأن اجتماع العقود مع بعضها لا بأس به. فما جاز مفردا جاز مجموعا إلا ما دل الدليل على تحريمه. So he clarified that it's permissible even if they were to be brought in together, same transactions, they have similar things brought together. He said what is permissible individually is permissible combined. And that's what he concluded with his research. So, as an alternative for the brothers, I think in the UK they call it PCP or some different wordings. People can resort to some of these contracts. Like for example, for Toyota lease, if you decide to purchase your Toyota at the end of the term, you will pay whatever the residual value difference is, plus tax and applicable fees. That's how it is. What if a person doesn't go on with purchase? Then there's another fee that he has to pay, a disposition type of fee. What is that fee? A disposition or turn-in fee is a charge to return your leased vehicle. The leasing company charges this fee to cover the cost of cleaning up and repurposing your old car for resale. So if you agree to that, that's from the fees. Let's give some examples now. If you're leasing a $40,000 type of car, $40,000 car, after 3 years you probably paid $18,000, for example. However, the car depreciated by $21,000. So now, when you complete, or if you want to back out of the contract then, you would have to pay the difference between what you paid of $18,000 and the amount of the car has depreciated. So you're going to pay how much? $3,000, brothers. You minus 18 with 21, the remainder is $3,000. Same thing, if you completed the term, then you will just pay $3,000 and you own the car. Pay $3,000, you own the car with some fees. That's why it's the benefit for some people to do lease to own. Because you're renting, on their term renting, paying installments, the value of the car is depreciating. By the time you've done the term, you just have to pay a little bit of a lump sum, and the car is yours. And the car is yours. So this is it in a nutshell, inshallah. What do we conclude with, brothers? That this transaction is permissible. And this is a fatwa of some of our mashayikh, that this is permissible. And now more and more scholars are permitting it, rent-to-own contracts. And if you say this is not permissible, and with people you're gonna force them into the other ones, the riba. This is not even riba, as they said. It falls into one of the definitions of bay'atain fi bay'ah, and it's not clear. And what's more apparent is that it's permissible. And والحاجة تدعو إلى ذلك, the need requires for this type of transaction right now, and people can introduce new transactions by the passing of time according to their needs. So this is it, inshallah. But yes, this is it, and generally, but each lease is still looked at separately. You have to judge every lease separately, because some leases, agreements have different clauses that you have to consider. Inshallah, we end with this. بارك الله فيكم سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت ونستغفرك ونتوب إليك.